If you're watching this, you're about to embark on the online CPD unit titled Mental Illness and Lawyers Ethics. My name is Alana and I'm about to take you through a short introductory video to prepare you for this session.
As you can see, mental health issues are highly prevalent within the legal community. Indeed, 80% of disciplinary matters are brought against lawyers with an underlying mental health issue. This tells us that mental illness is highly relevant to lawyers' ethics. So how does mental illness interact with lawyers' ethics in practice? This was considered in the case of Skerritt. The court indicated that mental illness does not necessarily mean that a lawyer is unfit for practice and should not be construed as such. Rather, mental illness only becomes an issue relevant to a lawyer's fitness to practice if it is so severe that it does undermine or detract from the carrying out of a lawyer's essential duties. In Skerritt, the appellant was successful on that basis. Although he had suffered an historical depressive episode, this did not render him unfit to practice law. In Skerritt, the court highlighted the following lawyers' duties: candour, honesty, competence to clients, and behaving with propriety and fairness. The duties espoused by the court in Skerritt are reflected in Rule 4 of the Legal Uniform Law Australian Solicitors Conduct Rules. In the case of Young, the respondent gave false evidence at an inquiry into electoral fraud. The court found that the respondent's emotional condition, a factor which contributed to her dishonesty before the inquiry, was not conducive to the upholding of lawyers' duties, and her name was removed from the roll of barristers in Queensland. So you can see a clear link there between her emotional condition, as the court put it, and a sense that she was unfit to practice, given that honesty is so central to the role of a lawyer. In contrast, the Victorian Supreme Court, in the case of Himmelhock, held that the defendant's mental health issues, which were believed to have played a role in his personal misconduct, did not warrant disbarring. In this case, the court drew a distinction between personal and professional conduct, confirming that mental illness will be relevant to a lawyer's fitness to practice if it adversely affects the carrying out of their professional duties, as was the case in Young. The salient point is that a lawyer's mental illness may become subject to the scrutiny of the regulator if it interferes with that person's ability to carry out his or her fundamental duties, such as those enshrined in Rule 4. If you are struggling with mental illness, reach out. There are resources available to you. Thank you.